Is a recent graduate of law school, just graduating and getting his or her first job, ready to step in court and represent clients? No. I had an incident that happened today that I want to share with you, and then I'll give me some thoughts on what I kind of observed from this. This was a young lawyer from a fairly large law firm, and we had a litigation matter, and there were a number of things that were done. There were errors by her. I've talked about a couple of them in previous videos, but today was mind-boggling. So what happened was we had negotiated this case, and I had come to a number that I thought was a fair and reasonable number and told her, that's it, that's my number. Either agree to that number or put your papers in. You know, you have every right to oppose my application. And obviously, if that's what you think is in the best interest of your client, you should do that. So I didn't hear from her at all. And today we appeared in court. So I was not really sure, was she going to announce to the court that she had reconsidered and we have a settlement because there were no papers filed in opposition to my application. And I appeared, she appeared, and the court actually asked me a question. Typically, judges will want to know what's going on with the case. Mr. Selbach, can you bring us up to date? And she interjected and began what I think was reading. She was reading something. And what she was reading was her opposition to my application. And I was a little surprised that the judge allowed her to continue, and he did. Obviously, it's not my place to interject at that point. And she laid out all of the things that she thought were in her favor and all the problems with my application. And I listened to her, and I simply said, I have no intention of responding to any of this. This is the first time that I have heard this opposition. There are no papers filed by this attorney in opposition, so I have no opportunity to prepare a reply to her arguments. Of course, the court is hearing this for the first time, and the court agreed and was very nice about it. I think because everybody recognized that she was new to the practice and simply indicated that you need to file papers in opposition to applications. You can't just show up on the day of the hearing and begin telling the court and your adversary your position, especially if they've never heard it before. Manifestly unfair, and obviously the local rules of the court set forth when responding papers are due, and then after that when reply papers to those opposition papers are due. She disregarded all of those. So what is my point here? This mistake is so obvious and egregious that obviously she had no concept of how this worked. And I really, as I thought more about it, I don't really blame her. I blame her supervising attorneys. Now, you don't really see this very often with large firms, because large firms usually have programs where they hook up a partner to a new associate and they supervise the associate, they mentor the associate, they walk them through the process, they answer their questions, etc. So you don't normally see this with a large firm. But with smaller firms, you could encounter this, so that you're in a small firm, and all of a sudden they start throwing files on your desk. Here, do this. Here, appear in court, without the slightest guidance. I cannot believe that no one sat down with this lawyer and said, look, if you're going to oppose this application, These are the local rules. This is how it works. You can't just show up on the date of the hearing and start making your argument. Maybe you did that in moot court in law school, but that's not how it works in real life. So what's my point here? If you're in a position where you're being asked to appear in court and you don't feel comfortable knowing the procedures, because just knowing the law is not enough. You have to know, how does this work? How do I oppose a motion? What are my requirements here? And obviously you want to sit down and look at the local rules to familiarize yourself with those rules, because local rules really show you the procedures. And these are set up by committees. I know, because I was on a committee at one point, and what the point of these local rules are to guide practitioners and the court to make the practice before the court efficient. If you're not comfortable, you need to speak to a partner. If you haven't been assigned a partner, just sit down and say, do you have a couple of minutes? I've got this case. The attorneys and we tried to negotiate a settlement. We weren't able to do that. I have to oppose his application. How does this work? I know when I first started practicing, I had sublet an office with a medium-sized firm, and even under that arrangement, once in a while I would sit down with one of the partners and say, this is what I've got. What would you normally do? And I didn't want to abuse that, but once in a while they were available for me to do that. But certainly somebody within your firm, within your office, who has experience, and they may just not be completely aware of the inadequacies that you possess as a new lawyer, because in law school you were taught the academic angle of law. There's nothing wrong with that. You have to have that. But there's a whole part of the law practice that you have to learn the ins and outs of it. And if you don't feel comfortable, you need to speak to someone. Now, I have something that I put together. It's called the New Lawyer's Guide. This is it right here. And it's the 3 things that you never want to do as a new lawyer. And you can get this free of charge at my website, which is teachnewlawyers.com. That's teachnewlawyers.com. Again, ladies and gentlemen, do not be afraid to ask questions of your supervising attorneys so that you can follow the procedures that have been established by the court.